Hello, everyone, and thank you for joining us for today's webinar, Lights, Camera, Action, Copyright Essentials for Filmmakers. My name is Alicia Morris. I work in the Public Information and Education Office, and I'm a host of today's webinar. Before we start, I'd like to share a few logistical announcements with you. During today's webinar, you will be able to submit questions using the Q&A function at the bottom of your screen. We will answer these questions after the presentation is complete. However, please keep in mind that we may not be able to get to all of the submitted questions. But please note that since this session is being recorded, if you choose to participate and your question is addressed, it will be included in the recording as part of this webinar. And now I would like to welcome our first presenter, Miriam Lord. Hello, Miriam.
Thank you, Alicia. Well, good morning and good afternoon to all of you. Thank you to the many of you joining us from all over the country to learn about how filmmakers fit into the copyright system and about helpful free resources the United States Copyright Office provides. My name is Miriam Lord. I'm the Associate Registrar of Copyrights and Director of the Office of Public Information and Education here. I have a background of helping people understand all of intellectual property law. And at the Copyright Office, I oversee the team that provides authoritative information about the copyright system and provides assistance to the public. You'll hear from some of those knowledgeable folks here today as we get into the details. We'll address some key frequently asked questions, especially for independent filmmakers and those business and legal advisors who support them. This series, Copyright Essentials, aims to serve you wherever you are on your filmmaking journey. Films inform and inspire us all, and it takes work to create them. As you'll hear today, the copyright system, powered by the Constitution, provides the framework to allow creativity to flourish. The U.S. Copyright Office priorities include making the copyright system as accessible and understandable to as many people as we can. This includes at all knowledge levels, all industries, and in all states. My great pleasure now to introduce you to my colleague who will lead today's conversation, Attorney Advisor Laura Kaiser. She and her colleagues have shaped this session and the Copyright Essentials series as a whole. This recorded explainer series has busted Copyright Office and copyright myths, answered frequently asked questions about copyright as it applies to photographers, visual artists, musicians, writers, and today to filmmakers. So thanks for your attention and your attendance. And now over to you, Laura.
Thank you so much, Miriam. Hello, everyone, and thank you for joining today. As Miriam mentioned, my name is Laura Kaiser. I'm an attorney advisor in the Public Information and Education Division of the Copyright Office. And along with my colleagues, I frequently participate in outreach projects like this webinar and very much enjoy explaining copyright law to the public. We are really thrilled that so many people want to learn and have joined the session today. And today we're going to talk about what filmmakers should know about copyright. So whether you're a producer, a director, a screenwriter, or a cinematographer, copyright is a tool in your toolbox that you should be aware of. So during today's webinar, first we're going to lay the groundwork with what the Copyright Office does, who we are, and then we'll talk about some copyright basics, the building blocks of copyright. Then we're going to get into some common questions that might come up for the independent filmmaker out there. And we're also going to spend a few minutes talking about the registration process and what to keep in mind when you're applying to register your work with our office. We're going to end the presentation today with a few words from a member of the Public Information Office, and then we'll leave some time at the end for Q&A. So if you missed the announcement at the beginning, please use the Q&A function to submit your questions. And with that, let's start with some background about the Copyright Office. The Copyright Office was founded in 1870, and we are a government agency that's part of the Library of Congress here in Washington, D.C. The Copyright Office is responsible for administering the Copyright Act, and that's a pretty broad statement. There's a number of different roles and responsibilities that the office has. So we'll talk a little bit about how the Copyright Office carries out its mission. So the office has several important duties that help fulfill copyright's constitutional purpose. Our mission statement is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright policy for the benefit of all. We have a small but mighty staff of about 450 employees, and we have many different responsibilities in the office. First, we make and maintain records that provide details on copyright ownership. So that includes registration as well as recorded documents that handle transfers of ownership. We also administer statutory licenses, develop regulations, advise Congress, and participate in the greater international copyright community. The top photo you see here on this slide shows us in our very important role of providing information to the public, which is of course central to what we do here in the Public Information and Education Department. So now that we know a little bit about what the office does, let's talk about those building blocks of copyright. Copyright law is found in Title 17 of the US Code. It's also known as the Copyright Act. And the law states that copyright protects original works of authorship that are fixed in a tangible medium of expression. So what do all those words mean? We're going to go through each of them now. So we must first have a work of authorship, and the work needs to be fixed and original in order for it to be protected by copyright. I'm going to let Miriam go through the works of authorship categories in more detail next, but I'll take a minute here to explain to you all what fixed means and what original means. So fixed just means that the expression needs to be captured or written or recorded somehow. So it needs to be sufficiently permanent and stable enough that you can see it, you can perceive it, you could copy it, or you could communicate it to others for more than a very brief period of time. The moment that you have all of these Now, originality in copyright actually has two different components to it. The first is independent creation, and the second is sufficient creativity. Independent creation means that the work needs to be original to the author. It needs to originate from the author and can't be copied from another work. So in theory, you could have two works that are the same or similar, and they can each have copyright protection as long as the similarities are just by chance and not the result of any copying. Sufficient creativity is the second component of originality, and that just means that the work needs to contain at least a small amount of creative expression. We say it just needs to be more than trivial. So I'll give you an example. If an author or an editor cuts a couple of seconds from a pre-existing film and submits a registration application to our office for that small bit, that 2 seconds of editing, that's generally not going to meet the threshold of creativity that we're talking about. So with that background, I'm now going to hand the mic back over to Miriam to take you through the works of authorship.
Thanks, Laura. So an author under copyright law is the creator in any discipline. And so the work of authorship term means it's the subject matter protected by copyright. So broad categories include, of course, motion pictures and other audiovisual works like movies, TV shows, video games. We'll be talking about some of that today. But also covered under that term of authorship, work of authorship term, are literary works, so books, poetry, textbooks, computer programs, musical works, including any accompanying lyrics, dramatic works like screenplays or operas, pantomimes and choreography, pictorial, graphic, and sculptural works, including fine and graphic art. Think of things like photographs, sculptures, and paintings. And then sound recordings and things like music, audiobooks, podcasts. And then finally, architectural works such as museums, houses, office buildings. So under copyright law, motion pictures are a type of audiovisual work. Other audiovisual works might include things like video games, webinars, virtual reality environments, karaoke displays, phone apps, all of that stuff. Motion pictures have their own definition in copyright, which I'll turn it over to Laura to explain further.
Thanks, Miriam. So as Miriam mentioned, motion pictures are a type of audiovisual work, and in the law, they're defined as audiovisual works that consist of a series of related images, and when those images are shown in succession, they impart an impression of motion, and that can include any accompanying sounds. So to give you an example of the distinction between a motion picture and an audiovisual work, think of a series of related photographs or drawings that are fixed, that are embodied in film stock, for example. That wouldn't be considered a motion picture unless, when shown, those photographs or drawings give an impression of motion. So motion pictures could include any of the items you see here, including feature films and short films, documentaries, music videos, TV shows, sporting events, and more. And as our audience today knows, creating a film is often a team effort, and there can be a number of different people or companies involved at different stages in the filmmaking process. So I'm going to turn it over to Miriam to talk a little bit more about the elements of a motion picture's authorship.
So considering the people involved is important for copyright because it helps you determine who is an author and a copyright owner. And in general, absent any complexities, the person who fixes the creative work of authorship in a tangible medium is the author and owns the copyright. So for photograph, the photographer. But for film, like Laura was saying, things get a little more complicated because there are teams of creative and business professionals might be involved throughout the life cycle of production. So generally, we have all of these creative inputs throughout the process of making a movie. So we got screenplay, possibly before that, a proposal or treatment, a synopsis, the production, the direction, the cinematography, all the performances, any editing, the soundtrack, and of course, any kind of musical score. So all these elements, we call them elements of authorship and copyright, come together in a single integrated work, the movie. This is significant because it means that the work of an individual member of the team, like a director's work or an actor's performance within a film, is considered part of the whole. So it can't be registered or protected by copyright separately. There's two possible exceptions to this general rule. The screenplay and the musical score could possibly be registered separately under certain circumstances. Over to you, Laura.
Thanks, Miriam. So I just want to take a moment and pause here and summarize what we've learned so far. So we know that for copyright protection, you need to have a work that's original and fixed. And we learned that motion pictures have their own category and definition in copyright. And that because many different creative and business professionals are involved, it can sometimes be a bit complicated to understand who the author and who the copyright owner is. We also know that all of the creative decisions that go into making a film, whether it be the cinematography, the direction, the performances, and the editing, that all ends up as one final product or work in copyright, and the whole work is what is protected. Now, we're going to take the next section to do a deeper dive on some common questions that might arise for filmmakers. Just keep in mind here that what we've done is collected a few questions that we think are going to help explain some key considerations for the independent filmmaker out there. And of course, we do have limited time with you all today, so we can't address everyone's questions from every possible angle, but we hope that this will point you to additional resources where you can learn more and make you more familiar with copyright terminology. And then after this section, we'll talk more about registration more closely. So I'm going to hand it over to Miriam to ask our first question.
Thanks, Laura. First common question is, my friend wrote the screenplay for my next short film. Laura, who's the copyright owner for each of those works?
Yeah, so for copyright, the question of who owns what, it can be straightforward if there's only a single person involved. That would be the person who creates the work. That would be the simplest scenario. And then that person who creates the work would be the owner of the copyright. So for example, your friend could be the author and the owner of the screenplay as soon as they write it, as soon as they type it up on their computer or write it down physically. However, the situation is more complicated by the fact that the screenplay later becomes part of that motion picture. And as we stated before, screenplays typically become part of that motion picture, and then they're considered to be part of the whole work, part of the movie as a whole, and they're not considered to be separate. Another complicating factor that we've mentioned is that motion pictures are a team effort. So there's producers, screenwriters, showrunners, studios that are involved at different stages. So what that means for copyright law and for the legal effect, it means that most movies, most motion pictures are what we call works made for hire under copyright law. So legally, when you have a work made for hire, the author is not going to be the creator. It's actually going to be the person or the company who commissioned the work or potentially an employer. So there's two different ways you could have a work made for hire. The first way is that it's an employee creating the work as part of their regular employment. So in that case, the employer is going to be considered the author and owner of the copyright in any work that's created by the employee. Motion pictures, or parts of motion pictures, though, are usually considered works made for hire as commissioned works. And that just means that there's a signed written agreement that states it's a work made for hire. And in that case, the person or the company that's commissioning that work will be considered the author and the copyright owner. So why is all of this important? Why is it important to know whether what you've created, whether your film is a work made for hire or not? Well, when you're applying to register your work with our office, you as the applicant will need to determine whether your film is a work made for hire. And if you have a work made for hire, it also can affect which registration options you choose, which types of registration applications you are eligible to use. Additionally, a work made for hire does have a different duration of copyright. There's a different copyright term. So copyright in a work made for hire is going to last 95 years from first publication or 120 years from creation, whichever expires first. If you didn't have a work made for hire, the copyright would expire 70 years after the author's death. And when that copyright term expires, the work enters what we call the public domain. The public domain is a body of material that's not protected by copyright. And that can be either because the term has expired, as we just explained, or maybe it was never protected by copyright in the first place. So things like facts and ideas are in the public domain. They aren't protected by copyright to begin with. And you don't need to ask for permission to use works that have entered the public domain. They are free to use. So with that background and some new key terms under our belt, we can turn to the second industry question. Our next question brings us into the production stage of a film. So let's say you're making a documentary and you'd like to incorporate some historical news footage and you're wondering, maybe this is fair use, maybe not. And I know a lot of people in the audience may have heard about this term fair use. So I'm going to turn it over to Miriam to give us the answer and explain more.
Great question. Keep in mind that fair use is a defense to copyright infringement, and it requires a fact-specific legal analysis that depends on exactly how you're using the footage and some other factors. As any good attorney would say, it's a pet. So you'll need to understand whether the footage is currently under copyright protection and then consult with an attorney on how you plan to use it. So just really briefly about fair use, we have a lot more information about this on the website if it's something you want to dig into. There are 4 factors that make up the statutory framework under copyright law for fair use. All of these are important. So the first is the purpose and character of the use. The second is the nature of the copyrighted work. The third is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And fourth is the effect of the use on the potential market for or value of the copyrighted work. So whether a use is fair or not is something that can ultimately only be decided by a court within the infringement context. So really remember that if you haven't obtained permission to use the footage in question or any footage in question, and if it's not in the public domain, you're relying on an exception or a limitation of copyright law if you're going to use that material. Fair use is one of these limitations, but it involves a complicated analysis, like I walked you through. It's a risk you're introducing into your film, and it's something you want to think about really carefully. So our next scenario involves incorporating music into films. So say there's a song would be perfect to use at the end of my movie. And I heard that if I pay a fee that's set by law, then I don't need to ask permission to use a song. Laura, is that true?
Thanks. So this is a question we know comes up for filmmakers often, and the short answer here is no. You can't just pay a fee and use a song in a film. Let's discuss a little bit more about why. So first, whenever you're incorporating a song into your motion picture, note that a song is actually 2 separate copyright protected works. So there's the musical work, which is the underlying composition. So think of something like the sheet music here. And then the sound recording is the recording of the song's performance. It's often called the master. So that means that you would need a separate license for each of those components if you'd like to use that song in your film. A license to the musical composition, that underlying musical work, is commonly referred to as a synchronization license or sync license. And then a license for the sound recording is often referred to as the master use license. So remember, there isn't a license that's set by the law that just allows you to incorporate a song into your movie or TV show without asking for permission. So you do need to negotiate that sync license or that master use license in the free market with the copyright owners of that musical composition or that sound recording. Now, outside of the world of audiovisual works, there is a mechanism that allows people to copy and distribute musical works via audio only. And normally, songwriters and publishers wouldn't be able to decline that request, but that particular licensing scheme does not actually apply to film. So just keep that in mind, that there is something called a compulsory license, and you might see that term floating around, but does not apply to audiovisual works or to film. Right, so we know that's a lot of information. Before we turn to the next question, I'll just pause a minute. And then for our second to last question, let's say you've completed your movie. Finally, it's done, and you're ready to submit it to various film festivals around the country. One of the film festivals gets back to you. They're very interested in showing your film. And one of the representatives starts asking you for something called chain of title documentation. So where do you start with that? And is that something that you might be able to obtain from the Copyright Office? Miriam, can you help us fill in some of the gaps here?
Thanks. Such a good question. The bottom line is no, the Copyright Office can't review contracts for you or give you legal advice. The office can't clear on your film or guarantee that no one else owns the material. But the good news is that the office does maintain a public record of copyright registrations and recorded documents. And you can access those records online in our Copyright Public Records system. You can also contact our Records Research and Certification Division, which conducts searches and produces copies of office registration records for a fee. And we can drop a link in the chat directly to accessing those services. But you can just find them on copyright.gov as well. So keep in mind and remember to avoid scrambling for the documentation after your film wraps or upon request from a film festival or distribution company. It's a good idea to keep track of all your agreements and all of the permissions that you've gathered from the beginning of the filmmaking process. So saving all this paperwork in one place, in addition to any relevant emails and your own notes, of course, will save you a lot of time later. It'll save you time, it'll save your legal advisors and business advisors time, and the team will be able to quickly and efficiently respond if you're asked to prove ownership of the material. All right. Our final industry question is a technical one. What if a distribution company has purchased the right to distribute my film? Laura, does that mean that my film is published for purposes of copyright? And why does this even matter?
Great. So publication can be a bit of a tricky copyright topic, and it is particularly important to know if your work is published and on what date it was published for a number of reasons. First, you will need to know when you're applying to register your work with our office. You'll need to know if your work was published or not. It also can affect the duration of your copyright, how long copyright is going to last in your film. And it can also be meaningful if there is a copyright dispute later on the road. So publication in copyright means that copies of your work were distributed to the public by selling it or by leasing it out, or maybe you offered to another group the ability to further distribute copies, to sell copies, or to publicly perform or publicly display the work. So I'll give you an example, offering a film to a distribution company, let's say, and that distribution company is going to go on and sell copies of your film or publicly perform the film. That's considered a publication. It's a publication the moment you make that offer. So remember here, though, that a public performance or a public display on its own is not a publication, and this can be a common point of confusion. So in copyright law, the public, we consider the public to be any place where a substantial number of people outside of a group of family, friends, social acquaintances, outside of where that small group might be gathered. So I'll give you an example. Let's say you have your movie playing at an outdoor film series in a local park, perhaps during the summer. That's a public performance. A park is open to the general public because and it's a public performance because in that scenario, you're not selling or transferring copies. So it's not a publication and you're not offering copies of your work to others to publicly perform, publicly display it. The work is just being publicly performed or shown on a screen. So that would be the key distinction there. All right, so that's our final industry question. Now we're going to move to the next section of our presentation today. We've covered so much ground for motion pictures. We talked about what a motion picture is under copyright law, the various elements of authorship. We went through all the questions that might come up for an independent filmmaker, or at least the ones we've collected just here today to give you some key considerations. And now that you all have some familiarity with some of these key copyright terms and topics like works made for hire and publication, now we can turn to copyright registration. Registration is a really important part of the office's work. So we want to take a few minutes here to give you both the basics, but then also some key considerations for filmmakers that might be embarking on the registration process for the first time. And we will drop a link into the chat, if it's not there already, to our registration portal. And from that registration portal, you can access a bunch of different resources pertaining to registration in particular. So with that, I will hand it over to Miriam.
Thank you. All right. So what is copyright registration, first of all? So since copyright protection is automatic and it starts the moment the work is fixed, like Laura said earlier, our registration with our office is voluntary. But there are important benefits when you register your work with the Copyright Office, where we administer the registration system for the United States. So this is where you come. One benefit is that the registration creates a public record, and that includes key facts about the work that's registered. This is helpful for the system. It's helpful for you as an author. It's helpful for other authors. Those details include the name of the author, the owner of the work, the title, the year the work was created, the year the work was published, if applicable, and the date and nation of first publication. They're all relevant fields that are shared. Registration record provides contact information for potential licensees who may want to seek permission to use the work, which could be a good opportunity for you. And importantly, registration is also a required component if you find yourself in a copyright dispute and you want access to federal court or the Copyright Claims Board. Several other benefits as well, but these are the ones we're going to talk about today. So before I move on, I just want as an important aside to explain what the Copyright Claims Board is. The Copyright Claims Board is a 3-member tribunal within the Copyright Office that resolves copyright disputes with up to $30,000 in damages at issue. So if a work is infringed, it has to be registered with the Copyright Office, or the office must have refused registration in order to file a copyright infringement lawsuit. If you file a claim with the Copyright Claims Board, you must, 1, have a registration from the office for the work at issue, or 2, have submitted an application to register the work either before or at the same time as you file your claim. You can find out more about the Copyright Claims Board on the Copyright Office website at copyright.gov, of course. So back to registration, we're going to go over some registration logistics. What's required for registration? It's a straightforward process. There are 3 basic requirements: completed application, filing fee, and a deposit. Deposit's just a copy of the work that you want to register. The application form will ask you to provide details, like the name of the author and the copyright owner, the title of the work, the year the work was created. We're going to talk a minute about the deposit copy, which enables the office to conduct our examination. So for motion pictures, the office requires submission of 1 complete copy of the motion picture. The deposit has to be submitted in a format accessible to the office, and all those formats are listed online. Additionally, the copy must correspond to the version of the work identified in the application. So for example, submitting a short clip from a motion picture when seeking to register the entire motion picture is not acceptable. If the motion picture is published, the deposit has to represent the published version of the work. Filmmakers may register works at different stages of a project. Remember that registration covers the work as deposited and not future revisions or cuts. So if a director's cut is later released, for example, that revised version would generally require a separate registration limited to the new authorship being claimed. With these benefits and the requirements in mind, I'll talk next about timing and application types. And then, of course, what we can do to help. All right, so how long is this all going to take? The good news is that in general, a claim to copyright registration takes months, not years, for the office to process. Processing times impacted by a number of factors, and we want to be as informative as possible to the public about our processing times. So we do list those on our website, both the most recent past and current registration times, so you can keep track. It takes the office far less time to process online claims with uploaded digital deposits that don't require correspondence with the applicant. Other claims, including those involving submissions by mail, can take longer. And keep in mind, and this is the most important part of this, that the effective date of copyright registration is the day on which an acceptable application deposit and fee have all been received by the Copyright Office. So those three things we talked about last time, we have the application, that's complete. We have the deposit, which is correct, and then we have the fee. When those have all been received by the office, that is the date that will be backdated in your registration. It's not when you get the certificate. Okay, so we'll get into a little bit of nitty-gritty here. We'll talk about a couple different kinds of applications, and then we'll point you to the website to dig into those after the session, if you'd like. So what type of application should you use to register your film? The type of registration application and the cost depends on the number and the types of works you're trying to register. The office has a few application types for film, each with specific eligibility requirements. Fortunately, it's pretty straightforward. Most works, including motion pictures, will use standard application. Use it for a single work, including a work made for hire or a joint or collective work. Standard application right now is $65 if filed online. For any fees, I'd point you to our website at copyright.gov, where all current fees are listed. So you have the most up-to-date information at all times. So we have the standard application. That's a good place to start. We've also created group registration options that allow you to submit more than one work per application, which saves you time and money. If your film works are unpublished, you may be able to take advantage of this. We have something called the group registration for unpublished works, where you can submit up to 10 on one application, for example, a series of episodes or something. Group registration option has several eligibility requirements, and we can't cover them all today, but one of the most important requirements that you should remember is that all the works must be in the same class, so work of the performing arts or motion picture, and they have to all be unpublished. We spoke earlier about the definition of publication, and this is crucial here to avoid mistakes. So work is unpublished if the copies have not been distributed to the public for further distribution, sale, rental, leasing, or lending, or copies have not been offered to a group for further distribution, public performance, or public display. If you're unsure whether or not your work is published or unpublished, or if you want to learn more about group registration options, we have a dedicated website with additional resources, including a circular, FAQs, and more. And you can navigate from the registration portal we linked to earlier, or you can call the Public Information Office, of course, and that group registration application is $85 right now. We have one more option that is usually not appropriate for film works, but we did want to mention it to you. It's called the single application. It has very strict requirements. It can be used only when the claim involves one work created by one individual author, where that individual author is also the sole copyright claimant. You can find all the current fees and application filing options on our website at copyright.gov, including ones that are not film related if you are multidisciplinary. Back to you, Laura.
Thanks, Miriam. So Miriam took us through copyright registration in a lot of detail, and we know that all of this information is just a lot to digest. And some of you might be wondering, I don't know how to get started. I really need some help with this registration process. So for the last part of our webinar today, we're going to introduce you all to a member of our Public Information Office, Rosemary Bronner. And Rosemary is here to tell us more about the work that she and her colleagues do every day. Before Rosemary introduces herself, just a couple of points to keep in mind when contacting our Public Information Office. Staff don't provide legal advice, so they can't help you assess whether your use of a work is fair use. They can't help you decide whether your work is published or not, or give an opinion on copyright infringement matters. But there is a lot of information they can and do provide. So with that, I'll hand over the mic to Rosemary. Thank you so much for joining us, Rosemary.
Thank you, Laura. My name is Rosemary Bronner. I'm a senior information specialist with over 30 years of experience at the Copyright Office and 20 years in the Public Information Office. I started 30 years ago filing registration applications.
Wow. So, Rosemary, what do you enjoy the most about being a senior information specialist with the Copyright Office?
I enjoy interacting with the public and answering their questions.
Fantastic. So yeah, Rosemary and her colleagues in our Public Information Office assist you all, the public, with questions about copyright law, the registration process, and other office services as well. Rosemary, can you tell us a little bit more about how all of that works?
Yes, ma'am. We answer your questions by telephone, email, and in person if you visit our office in Washington, D.C. We also have a service called a walkthrough appointment, where we help you complete your online registration application over the phone. Even though we cannot provide legal advice, we can give you information to help you reach decisions about how to answer application questions. Walkthrough service is by appointment only using the contact form on our website, copyright.gov. A person can also request certified copies of registration certificates and deposit. So, a deposit is another name for a copy of your work that you would submit with a registration application and fee. Members of the public can also submit requests for a search of the office records on our website. This is a service often used by people who are interested in investigating whether a work is under copyright protection and to learn the facts of the copyright. For example, wanting to know the copyright owner's name.
Great. Thank you so much, Rosemary. So in our audience today, we have lots of filmmakers or their legal and business advisors. So it would be great if you could give us a little bit more information about what kinds of questions you get from filmmakers generally and how you would typically handle those in the Public Information Office.
Sure, we receive lots of questions regarding registration for motion pictures. For example, someone might call us wondering if their film is considered published when it was shown at a film festival. To answer that, we will point the person to the definition of publication in the copyright law that Laura talked about earlier. Ultimately, it's up to the applicant to determine if the work was published when they apply for registration. But we can point you to resources that discuss the concept in further detail in the context of motion picture. Another question we often receive is whether someone can use the single application to register a selfie video, a video that a person takes of themselves. To answer that, we will point the person to the requirements for the single application. The video must have one author, who is also the copyright owner, and it cannot be a work made for hire. A selfie video that also meets all the remaining requirements may be eligible for the single application. Those are just two examples, and we realize that our audience today may have many more. PIO is here to help. So thank you again for being here today. I'll hand the mic back over to Laura.
Wonderful. Thank you so much, Rosemary. So yes, as Rosemary mentioned, please do contact our Public Information Office, or PIO for short, if you have questions about copyright generally, or if you're submitting a registration application and want to have some questions for our staff. Remember, you can access all of the resources through copyright.gov, and we also have the phone number for our Public Information Office on the slide. And we're going to drop in the chat, if we haven't already, a link to our contact page. And from there, you're able to specify what kinds of questions you have, and it will be directed to the appropriate staff in our office who can help you further with all the many questions we know you have about copyright and how it informs your filmmaking and your creative pursuits. So with that, we have covered a lot of content today, and we're very happy to take questions from our audience. I'm inviting our public affairs specialist, Ann Tatro, who's going to be helping to moderate our Q&A section for today. So over to you, Ann, for the questions.
Thank you, Laura. Happy to be here and share some questions from the audience. We'll try to get to as many questions as we can in the time that we have. Rosemary brought up some common questions she received in PIO regarding the single application and publication. And of course, you both have answered many questions, but there's always more. So we do have some additional questions about registering a motion picture. This one will be to you, Laura. I want to register my screenplay, but have confidentiality or business concerns about submitting the full script before the project is released. Do I still need to submit a deposit copy?
Yeah, that's a great question. And we know it often comes up for people who are concerned. So the answer is yes, you do still need to submit a deposit copy when you're applying for registration. As Mary mentioned, it's one of those three key components when you're submitting the application, deposit, and the fee. However, the office can accept a redacted version of a screenplay for a film. Um, that just needs to have certain requirements need to be met. So those are all listed and you can access those via the website to see what exactly the requirements are for submitting something that's redacted to the office. And then the applicant would also need to request special relief from the deposit requirements. So it's possible, but you just need to make sure all the boxes are checked for that.
Great, thank you. And we do have a couple more questions for you, Laura. The second one, I wrote the screenplay for a film and my friend directed the film. Can we register this motion picture as co-authors?
Yeah, great question. We didn't talk about joint authorship in depth today, but that's basically what this question is getting at. So co-authors kind of points us to joint authorship. So the answer for film is possibly, right? You could have co-authors or joint authors. The requirement there would be that you and your friend, in this example, you had the intention to merge your contributions. So in the law, the terms that are used are interdependent and inseparable, which basically just means that you and your friend intended that both of your contributions cannot be separated from each other in the final work, that they are dependent on each other for making that final motion picture. Practically speaking, most motion pictures are going to be considered works made for hire, but it is possible if you meet the requirements for joint authorship. Great question.
All right, the next one, again, for you, Laura. My screenplay was never published on its own, but a film incorporating the screenplay was released. Can I still register the screenplay as an unpublished work?
Yeah, this is another good one. And the reason why we spent so much time talking about publication and making sure that you all understand that that's a really important part of your creative process is understanding when your work is published and whether it's published or unpublished when you register with the office. So definitely a good idea to remind yourself of that definition and check out our website for additional supportive materials there. Generally speaking, when you publish a motion picture, all of the components, everything that goes into that motion picture is also going to be considered published. So that's true of the screenplay as well. The screenplay is published as part of that motion picture as soon as that film is published. And then you wouldn't be able to register the screenplay then as an unpublished work. You can't take it back out of that status and register it as unpublished. So generally speaking, once it goes with the motion picture, it's part of that motion picture, and it can't be then taken back. In certain cases, there might be a possibility for an unpublished screenplay first, but I'll say that those instances are rare, and it's really going to be fact dependent on your specific circumstances for that kind of application. Great question.
All right, we do have some more registration questions. Laura, again to you. I made a feature length. I made a feature length movie that incorporated scenes from my initial short. Do I have to note this on the registration application?
Yes, you do. Any existing material, so whether that is footage or photos from in a documentary, let's say if you're trying to use some footage like we talked about earlier with one of our questions, any of that pre-existing footage, you do need to note that when you're applying to register, and that material is generally then excluded from the eventual registration. So it does come up more often with documentaries, but it can come up in other works as well, where you're incorporating material that has already been existing and has already been created. Yeah, love these registration questions. Remember, you can always contact the public information process. We know that it can be really detailed and you want to make sure you understand all the terms and all the questions. So that's why our public information office is here to help with those details. But yeah, happy to answer any more we have, Anne.
Yes, there is one. Actually, I'm gonna have Miriam answer this one. I included some AI generated material in my music video. Can I still register the copyright?
Thanks, Anne. Great question, very topical. Yes, you may, but we do have specific guidance about this. On our website, there's an AI landing page that includes all of the information related to registering a work that's made using AI generated material. Just like you would disclose any disclose and disclaim any pre-existing material you're going to disclose and disclaim any AI-generated content on the registration application. Now, the guidance that we've published is pretty straightforward. You just need to indicate that that has happened. You may go into correspondence with the examiner. They may ask you additional questions. The office at this point has registered more than 5,000 works that have included AI-generated material, so it's definitely possible to do. But just be careful, follow the instructions in the guidance that we have, and let us know if you have any questions. Thanks.
Thank you. Okay, back over to you, Laura. We do have some more questions. It looks like we have a little bit more time for responses. So this one, can I register my treatment and synopsis and copyright the idea for my motion picture?
Yeah, this is a great question. So we know that, a treatment or synopsis, Miriam mentioned this when she was talking about the elements of authorship. That might come before, a script or a screenplay is written. So the important thing to note here is that it goes back to those building blocks of copyright we talked about, right? Once you have a work of authorship, it's fixed and original, that's protected by copyright. So text, can be registered as well because literary works are a form of authorship. Once they're fixed and original, they can have copyright protection. The important thing to remember here, though, is the underlying ideas in that treatment or synopsis, those cannot be protected by copyright. So you just have to remember that the specific expression, the specific words used in that text, in that treatment or synopsis, that's what's going to be protected, not any underlying ideas. Great question.
And it does look like registration is the hot topic for a good reason. Laura, again, this one for you. I've heard that I need to send a best edition copy of my work to the office when I register. What does that mean for my short film?
Good. So for short films, it's true the same for feature-length films or short films, the answer is the same. For films that are first published in the United States in a hard copy and electronic format, if it's in hard copy only or in both of those formats, you have to send in one complete hard copy of the best edition of the work. And all of the requirements for the formatting and what that means, that's all available on the website and kind of gets into the weeds of what we require. For films that are only published in electronic format, you just submit the digital file of the work. But generally speaking, if it's in hard copy and electronic format, you do submit a hard copy best edition. So if you have any questions about that requirement in particular, feel free to contact the office. We'll point you to the right resource so that you can make sure that you hit all the requirements and do everything you need to do as part of your registration.
Got it. This question, it looks like it's about a revised edition here. What about a treatment for a television script that has been reworked? Would the treatment and the original script writer still hold some authorship? Or does that transfer when the second and third drafts are written?
Yeah, this question kind of gets at maybe different versions of something and, at what point you register. And that's something that, you would decide either on your own or with a legal or business advisor at what point you register in your drafting process. Just keep in mind, as Miriam was mentioning with that director's cut example that we used before, any new revisions or new cuts, those would each have to have a new registration application for our purposes, because when you register the original, it's only what's included in that deposit copy that's protected. So if you're then submitting a new version, it needs to have new material added that meets the requirements for copyright. So generally, things like fixing a couple of grammatical mistakes, for example, or some spelling errors, that's not going to rise to the level that a new application would be registered because it doesn't have enough new authorship. There's not enough new creative material that's been added. But if you've added, let's say, 10 new scenes, that's probably going to be enough. That's enough new creative material, and then you could submit that for registration, and then you would just disclaim the part that was already created and already registered. You would say, I'm just registering this new authorship. So hopefully that answers your question and gets at that versioning question. I know that can be tricky for a lot of people.
All right. There was a question, and maybe it was answered during the presentation, but enough to revisit. So for a screenplay, is the Writers Guild registration enough? Why add the copyright registration?
Great question. This is a good one to clear up. So for copyright, we're the only agency, we're the only entity that can give you a registration certificate. So that's important to remember. The Copyright Office is the one that processes copyright registrations and issues registration certificates. Other entities might have registration processes. That's all separate from what we do in the office for copyright. So we take in registration applications, they're examined by our Department of Registration, and then if it meets all of the requirements for our procedures and it meets all the requirements for copyrightability, then we're issuing those certificates. So anything with the Writers Guild that's registration, that's separate from our processes and involves separate requirements and separate benefits. All of the legal benefits that Miriam was mentioning in that section on registration, that's only applicable for our registration purposes and process. That's a good question.
Thank you for that clarification. Looks like we also need a bit of a clarification for the group of unpublished works application. This question, do you have to have all 10 episodes available at a time for a group registration?
That's a good question. I know that the requirements say up to 10. I don't know for a fact whether or not you need to fill all 10. That's a good question to ask PIO just to make sure that what you're submitting and the deposit copies are lining up. So that's a good question to take a look at the registration portal, take a look at the guidelines, and just make sure you have all the boxes checked. Miriam, do you have some additional information you can share there?
Sure. So the plan, the idea with the group registration options in any area of registration and for film specifically here is that it's designed to be a tool to make the system more accessible for you. However, we're not going to examine the application until it's complete. So if your goal is to get the application processed, submit it with up to 10. You have up to 10 to submit. You can file supplementary registrations, which is a way to add more information to something, but there are a lot of rules about what can go in that and what can't. So I think if you're very prolific, you'll probably find yourself batching things and then just checking with PIO, with our office or with the advisor or clinic or something as to whether, just to be sure, they're all unpublished works, they're all in the same class, and whatever you're giving us as a deposit meets our requirements so that we can very efficiently process the registration, give you a decision, and then if it's registered, get you an effective date of registration that you can depend on. Great question.
Great, thank you. Laura, I do have an additional question, just what type of video does fall within the audiovisual and motion picture works? Someone is inquiring if a YouTube storyteller or talking head does fall under this motion picture registration process.
Yeah, that's a good question. It could, I think it's something that you would need to know kind of all the facts around it, but generally speaking, as long as it meets the definition for a motion picture, it's also going to be considered an audiovisual work, right? So audiovisual works are like the bigger umbrella, and then motion pictures are one subcategory as part of that. So as long as you have something that, has those, as I said before, those images that are related, that are in motion, even if it's just one person speaking, that could be a motion picture, certainly.
Great. And it looks like we have time for a couple more questions. Miriam, I have this question for you here. Does the Copyright Office have issue spotting, real world case studies available for awareness raising purposes? And if yes, what are the topical registration, film or music work studies available?
Sure. I think that this is going to take us into the resources we have available. So I think we can transition into that, but then also just be aware that, of course, we have hundreds of people online. We have many questions. All the questions are great. These are important questions to ask yourself, to ask your counsel, to ask the office as you work through things. So just because we're running out of time doesn't mean that we can't help you, as a next step. So yes, the office has lots of materials, and we'd be happy to, make links available again in the chat so that you just have them all in one place. And then I can go into some of those resources and answer this question and also accomplish some of our wrap-up activities. So one of the resources that the Copyright Office has that I want to point you to is the Copyright Registration Toolkit. This toolkit doesn't answer to the question of case studies, but I want to talk about it first just because it's designed to be a really visual toolkit to help you walk through the registration process. It helps you think about what this is, what it means for you, what types there are available, what you need to get together before you get started, and answers all kinds of questions for you about the duration of copyright and points you directly to the resources that you'll need. So please check that out. From there, you can also learn more about other areas of IP and follow that train if you need to for things like your brand. Other resources we have available and those that answer the question are the Compendium of Copyright Office Practices is a resource available on our website. That's a good place usually for legal and business advisors to look at, but also pro se filers or creators. It's very dense. It essentially takes this Copyright Office statute, this is Title 17 of the US Code, and breaks it into something closer to plain English and talks about how the office administers that law. So it'll have some details in there in the film section, just about some examples and how the office would treat that particular example. So that's a real deep dive to take. Before you dive into that, I might suggest you check out things like our motion pictures registration portal page, which you can see up here sort of spliced into the screen. You can also check out quite a few of our other resources, YouTube videos, things like that, and circulars. Circulars are designed to be a really accessible text-based resource that helps you walk through specific requirements, especially those pertaining to film for your purposes, but also covering other areas as well. Other resources we have, I want to stress again, the Copyright Public Record System. This is where you're going to conduct searches. This is where you can see your own registration once it's been, once it's live. And then of course, don't forget our Public Information Office staff who can help walk you through things or just really even triage the questions that you have and separate the ones that are good for the office, things that you can help yourself on, and things where you might need to seek legal advice. The office has resources such as an email listserv. It's called our Newsnet. We're excited this year to celebrate the 50th anniversary of the 1976 Copyright Act. This is the basis of the current copyright system. And we'll be having a year-long campaign to celebrate and mark that occasion and promote a lot of education around copyright generally. So you can stay tuned for further announcements from the office by subscribing to that. Where we also share updates to things like our blog, event announcements, and legislative developments. So we encourage you to follow us on social media like X and LinkedIn. And I'll encourage you as well, since we're wrapping up, just a reminder that we care about your feedback. So we've gotten a lot of live feedback from all of you as we've been walking through, and thank you to Aon for moderating. That's all very important to us. We will take that back. It helps us to inform further resources that we develop. So your request could become a real live Copyright Office resource someday. Please do take the survey that we're going to send you. We want your feedback on today's event and on resources that we have, and we wish you the very best in all of your filmmaking. So thank you all. And thank you to staff for hosting today's webinar.